Welcome to Canadian Justice. I'm Christine Van Gyn. Well, the federal court has finally ruled on the legality and constitutionality of the Trudeau government's invocation of the Emergencies Act. The Emergencies Act was invoked in response to the 2022 Freedom Convoy. These protests, which had blocked streets in Ottawa and blocked borders in Ontario, Alberta, and Manitoba. The Canadian Constitution Foundation, which is the charity I work for, along with the Canadian Civil Liberties Association, challenged the invocation of the Emergencies Act as illegal and unconstitutional. And the federal court has sided with us in a massive victory. The federal court held that the legal threshold to invoke this extraordinarily powerful law was not met, that no national emergency or threat to the security of Canada existed. The court also found that the regulations under the Emergencies Act were unconstitutional. These were regulations that prohibited certain types of gathering, which violated freedom of expression, and which froze bank accounts, which violated the right to be free from an unreasonable search and seizure. Here today to discuss the decision are three of the lawyers who were involved in the case: Joanna Barron, Executive Director of the CCF, Sujit Choudhry, who represented the CCF, and Eva Krajewska, who represented the Canadian Civil Liberties Association. Thank you all so much for joining me today. First off, congratulations, an incredible victory, and thank you all so much for doing such an excellent job. Joanna, I'll start with you. Why don't you give your high-level reaction to the decision?
Well, it's a historic case. It's a precedent setting case. This was, of course, the first time the Emergencies Act was invoked in its relatively short history since it was adopted to replace the War Measures Act. And it's an incredibly clear reaffirmation of basic principles of statutory interpretation and the rule of law. It sends a clear signal to future governments that they have to read the act and follow the tests that are prescribed by this very specific statute that grants extraordinary powers.
Sujit, same to you. High-level response, reaction to this victory.
So the reason we took the case is because we wanted to check executive overreach and we wanted to protect political freedom. And the cause or the motivations weren't ideological, right? This act could be used against any type of protester from any background. And we spoke in the language of constitutional principle, and the court accepted it, and we're delighted.
Eva, same question to you. What's your reaction to the federal court decision?
I think, I mean, the CCLA brought this application in part to ensure that there was a check on government action in the future and provide guidance to future governments as to when and how they can invoke this act. And now we have that. We have clear guidance as to what these provisions in the act mean and when it can be invoked, which is very good for our democracy.
So some of there are different provisions in the act. Some of them talk about national emergencies. Some of them talk about threat to the security of Canada. Now, Joanna, on this question of no national emergency, what can you tell me about what the court said about that?
Yeah, so Section 17(2)(c) of the Act talks about whether the nature of the emergency is national in scope. And if it's not, it can actually be specified when the Act is invoked that applies only to certain parts of the country. Here, the Governor and Council did not do that. So the Act was enforced throughout the country. And there's some sort of vague language that there was an emergency happening in quote unquote various locations throughout Canada. Justice Mosley did not accept that and found that really, the concern was limited to the Ottawa region since the situation at Coutts and Windsor and other places had been resolved well before the invocation of the Act.
Sujit, anything you want to add on this finding by the court that the term national emergency had not been met by the situation?
Yeah. So, in Canada, our policing is federalized in the sense that our provincial and municipal police forces are the first line of response under municipal law, provincial law, and also the federal criminal code. And so the question for the court was whether the normal way in which we do public order policing was insufficient. And the answer is that the court wasn't satisfied that it was insufficient. The government hadn't met its burden. And so the court's kind of approach to the lack of a national emergency was a ringing endorsement of policing federalism and the need to let provinces take the lead on these issues.
Now, another part of this decision relates to the requirement for public order emergency that there is a threat to the security of Canada. And that is a term that's defined in the Emergencies Act by reference to the CSIS Act. Now, Justice Mosley in the federal court decision found that there was no threat to the security of Canada. When we come back from this commercial break, I want to talk about how he reached that conclusion.